Good afternoon, everyone. Good afternoon. Good morning. I'm thinking that perhaps some members will be joining as we start the presentation. I just wanted to confirm for everyone that's joining us that I just posted Frederica Wilson's presentation on our website. So if you're locating today's CLE event, then you'll see the PowerPoint presentation is posted online. So I tried to do a little bit of a bit of my homework to click on some of the hyperlinks as we did the presentations, but I'm having a little bit of struggle to make sure that the presentation will flow. So I won't be clicking on the hyperlinks, but they are available. Obviously, they work fine in the PowerPoint slides. And if you have any questions as the presentation moves forward, just raise your hand. Happy to take questions. And I'm so delighted that Frederica was able to travel to Iqaluit to deliver in-person sessions as part of our efforts to provide support to our members in terms of anti-money laundering and trust accounting rules. This is the first session on AML. The second session, most likely end of February, will be focusing on trust accounting rules. And we've been developing a toolbox for each of these important topics. So I'd like to welcome again Frederica, who the first time came to Iqaluit in September. We did not connect as we would have hoped for because of Blizzard. But in November, it's like +3 today in Iqaluit. So I'm glad Frederica is not constrained by weather, and she's able to spend some time with us up here. But I am worried about Mother Nature, obviously. So, Frederica, I thought I'd invite you to share a little few words about your past experience, who you are, and yeah, over to you.
Thanks very much, Nalini. Welcome. So until about 18 months ago, I worked for the Federation of Law Societies of Canada, which is the coordinating body of the territorial and provincial law societies. I worked there for 18 years and was responsible for all of the Federation's policy work, including its work on anti-money laundering. So I've continued to work a little bit through my retirement, providing some support to the Northern Law Societies and more specifically to Nunavut. And it's in that capacity that I'm here with you today. So this session is intended to be a kind of a high-level overview of the what we call the anti-money laundering rules. We'll start by just a little bit of context and then get into the meat and potatoes. Uh, First thing I want to say is that these rules seem to unnerve people a bit, but the main message that I want to leave today is it's actually pretty straightforward and not no need for anxiety. Um, so we're going to talk a little bit about why law societies regulate in this area, what the rules, the Nunavut rules are, and where you can find them. And as Nalini mentioned, we'll introduce a few practical tools that the Law Society has been developing to help members comply with the rules.
And I was going to say, Frederica, as we're going through this presentation, inviting our members, if anything comes to mind that you feel there are tools that would be beneficial to you, please, if you don't have, if that idea doesn't come to mind today, but it comes later, please share those ideas because as we're developing the toolbox, we want to make sure that we're meeting the needs of our memberships and our members.
Yeah, absolutely. So just to put the rules in a bit of context, I'll give you a bit of a history lesson. It's going to be brief, don't worry. Um, Law societies have been involved in the fight against money laundering and terrorist financing for more than 20 years. You'll hear me refer only to money laundering. It's just because it's shorter. All of these rules are aimed at mitigating both money laundering and terrorist financing risks. The Law Society's work in this area started initially because the federal government introduced legislation that would have required lawyers to report secretly to the government on activities of their clients involving suspicious or large cash transactions. You can imagine that that was met with concern by the regulators and by the members of the profession at the time because of concerns about interference with the lawyer-client relationship and breach of solicitor-client privilege. This led to a legal challenge in 2001, which was successful. It resulted in an injunction preventing the government from imposing these regulations on lawyers. And that led to an agreement to in the way of litigation, there were separate actions brought in different provinces, but after a few, it led to an agreement with the federal government to not impose and not attempt to impose any provisions on lawyers without the agreement of the law societies. And on we went for a number of years without any particular problems. Um, but the legal challenge, which had been suspended following that agreement, was resumed in 2011 when the government indicated they would like to impose client identification and verification obligations on lawyers with reporting, which would have had reporting obligations for lawyers and also an obligation to surrender any documents to the federal government upon demand, essentially. Ultimately, in 2015, the Supreme Court of Canada ruled in favor of the Federation's case that the provisions, as they applied to legal counsel, were unconstitutional. That's a little bit of the legal history. So then working through the Federation, and when I say Federation, I mean the Federation of Law Societies. The Canadian Law Societies have developed and implemented three model anti-money laundering rules. The first is the model rule on cash transactions, which I'll describe in a moment. That was first adopted in 2004. That was followed by a model rule on client identification and verification, which was first introduced in 2008. And finally, a model trust accounting rule, which was introduced in 2018. And I'll talk primarily about the first two rules, but I will touch briefly on the model trust accounting rule as well.
And as I was mentioning, the next session, probably late February, we're going to be focusing on the trust accounting rules.
Yeah.
Yes.
Yeah. So in Nunavut, there are two sets of rules in effect currently, which have as their purpose mitigation of money laundering risks. And the first is, I mentioned, the cash transactions rule. You'll find that at Rule 80.1. It's fairly brief. And then the client identification and verification rules, which you'll find at 80.2 through 80.9. So, dealing first with cash transactions, the goal of this rule is very straightforward. It limits the value of cash that a lawyer may receive in relation to any single client matter. So it's not just per client, but per client matter. If you had a client where you were doing multiple things for, then the amounts of cash that you could receive would be higher. So what's the limit? It's an aggregate amount of $7,500 in relation to any client matter. There are some exceptions. Somehow I managed to Nalini thinks this is good. I hate
It's
it.
a team effort.
I somehow managed to put some kind of animation in this particular slide. So pardon me for my ham-fistedness with it. The exceptions, which are really modeled after some provisions in the federal legislation, or if the money is received from a financial institution or a public body, received from a peace officer, the Crown acting in their official capacity, money that's used to pay a fine or bail or a penalty. And the most controversial exception is money received for professional fees, um, disbursements, or expenses. That's controversial because, unlike the others, which involve external parties, the money received for professional fees, disbursements, and so on are really a matter between the client and the lawyer. However, that exception has been maintained in spite of our move to a more cashless society, because the advice that we get from lawyers across the country is that they do still deal in cash in some cases for these matters. To um, to make giving money to your lawyer and then getting a refund an unattractive way of laundering money, refunds of any money received through one of these exceptions must be made in cash. I hesitated there a moment because what I haven't gotten into at all is any details about how money laundering takes place and what it looks like. And for that, I would invite you to take a look at the materials on the Federation of Law Societies of Canada website. We provide a link in the presentation further on, where there is quite extensive information about not only resources for lawyers, but also information on money laundering and what it looks like, particularly in a 5-module online education program, which I would commend to you. Um, so this rule was brought in, and the limit was set as an alternative to large cash transaction reporting. And at that time, the large cash transaction reporting limit was $10,000. The Law Societies wanted to set a limit that was lower than the federal government limit, which is how we end up with $7,500. To help you, the Law Society has developed one of the tools in the new toolbox is a receipt of cash checklist, which really serves as both a record and a checklist. Uh, if you take a look at that when you have a moment, you'll see that it asks a series of questions, and those will guide you really to whether or not you can accept cash in the context, or whether in fact you cannot accept cash in that context. And that's the goal of this checklist. As Nalini mentioned, the Law Society has identified what it thinks lawyers need to know, but also is still working on identifying ways in which the Law Society can help provide tools, provide information to assist lawyers in complying with these rules.
And just to be a bit more clear, so we've asked Frederica to help us build that baseline foundation of what you need to know and why with these new tools. So hopefully, as we continue on with the session, again, I was mentioning if there's anything that you feel that is missing in your practice, I'd like please let us know. We're happy to kind of a building block approach with our efforts to provide educational tools.
And I should just reiterate here that if you have any questions, we have just an hour, and so I may tend to sort of go a little bit quickly, but I'm more than happy to ask specific questions now, answer specific questions now if you have them. Don't hesitate to
Raise your hand.
put up
Yep.
your virtual hand, and we'll Nalini's keeping an eye on that so that we can answer them. So that's the cash part of it. Pretty simple, straightforward. You'll see the rules are quite short, in fact. There's some record keeping associated with it, but not it's not complicated or onerous in terms of what's required. The part of the rules that seems to throw many lawyers across the country are the client identification and verification rules. Part of the issue, I think, is that they're long. So really, that makes it look complex, and I don't think it really is that complex. So let me just start by giving you a high-level overview of the structure of these rules. The first is that there are two concepts, identification and verification. As I'll get into more in a moment, identification applies to pretty much every context where you have a client. Verification applies in more limited circumstances where there is a financial transaction involved. In the rules, in addition, there are specific rules for when you are dealing with an individual client, or an instructing individual for an organization, and when you deal with an organization itself, when you must identify or verify organizations. So I'll touch on that as we go forward. The very first thing that the rule requires is that and that's 80.3A, is that you obtain and record the name, address, phone number, occupation, work address, and phone number if there is one, of your client, and the applicable date of identification. This is for individuals. Pretty straightforward. I think yeah, I was in private practice for a long time before I went into the work at the Federation, and I don't think I ever opened a file without getting this basic information. I think it's pretty standard, though I appreciate that if you haven't, if you know somebody, you may be a little inclined to be a little more laissez-faire about it. But this sort of information is generally not something that clients have resisted providing in the ordinary course of business.
And yesterday we did an in-person session for members of the private bar, and we were just discussing, like in Nunavut, everybody knows everybody. And then, are we feeling uncomfortable because we know who our client is? We've known them as part of our environment or our daily lives. But we came up with a proposal to say, just say this is a law society requirement because you're practicing law. It is a law society requirement. It's not a lawyer's, it's not the lawyer deciding that they need to do it. It's us telling the lawyers, you must do this. So,
I should tell you that these rules, again, are modeled on the federal government legislation, not because we wanted to play copycat, but there were strategic reasons for doing that, made it more difficult for the federal government to attack the rules or criticize them. But as a consequence, many of these things, all kinds of other organizations are already doing with people. Banks, if you're working with a real estate agent, they are covered by the federal government regulations and so on. And so compared to where things were when we started, I think that most or many people are familiar with being asked these questions through other contexts. So as I mentioned, there are different provisions for organizations, organizations being corporations, trusts, partnerships, etc. Um, uh, and the different provisions are really just because obviously there are it's a different context, right? So again, full name, business address, telephone number, incorporation or business identification number if they have one, the type of the business, and then the name, the position, and the contact information of the person who is authorized to give instructions. It's when you're dealing with an organization there, you always have to deal with some individual to get the information.
yeah, making sure being really mindful of, because there's a lot of transition as well in our territory. So making sure you reconfirm who has the authority to give those instructions. And even if there's there's a CEO, there's an ED or whatnot, if it's a different person who's authorized, you need to obtain and verify their identification.
That's right.
Yeah.
When the rules about identifying individuals
Mm,
apply also to that instructing person. And Nalini's quite right. It's something that you need to stay on top of when a file goes on for a while or when you have a client with multiple matters,
mhm.
as the instructing individual may change. And in each case, whether it's an individual or an organization, you have to record the information. You need to give and put the date down in which you got the information. There are some exceptions when you are providing legal services to your employer. I, for example, as a practicing lawyer, when I worked for the Federation, um, and I did provide legal advice to my employer. In that context, I'm not required to identify them. When you're acting as an agent for another lawyer, when you're acting on a referral from a lawyer who's done the identification, or in most cases when you're acting as duty counsel, you don't need to identify the client in those contexts. So now we get into the part of the rule that gives most people the most trouble, and that is verifying identity. This applies whenever there is a financial transaction involved. And when I say there is a financial transaction involved, the lawyer doesn't have to be doing the transaction for the client, but if the lawyer is instructing the client, advising the client on the financial transaction, or any of those things that involve a financial transaction, you must verify the identity. So in those cases, you must do two things. One is to verify the identity, and that's dealt with in Rule 80.6, sub 1, sub B, and obtain a copy of the documents that you rely on. The other thing you have to do, which we'll get into a little bit further along, is to obtain and record information on the source of funds for the transaction. And you'll find that rule at 80.61A. Okay, again, we have details on how to verify the identity of an individual and details on how to verify the identity of an organization. So starting with identifying individual, verifying the identity of individuals, there are four ways, but even as I tell you that there are four ways, I'm going to tell you that most people are relying on one of two ways. So the four ways are relying on photo identification issued by a government. That could be federal, provincial, territorial, or foreign government other than a municipal government. The second way that I am told is never used, but for reasons that aren't relevant today, still remain in the rule. Information contained in a Canadian credit file. Can certainly rely on it if you wish, but I gather that lawyers have found it inconvenient and they don't use it. The other way, which is sometimes used, is relying on information from any two reliable sources that contain the individual's name and address, or their name and date of birth, or their name and confirmation that they have a deposit or a loan account, a credit card, that kind of thing. We call that the dual method. And finally, you can use an agent to do any of these to do any of these things for you. So there's technically a fourth way, although the agent is obliged to verify identity in the same ways that are available to the lawyer themselves. So currently, the rule in Nunavut requires that if you're relying on any of the documents you're relying on must be valid, current, and original. There has been a change to the model rule, and some law societies, but not all, have implemented it, and that is to say that documents must be valid, current, and authentic, which is a change that permits reliance on digital authentication services, which exist. And there is an organization, I just can't, as I sit here, remember the proper name of it, but it's abbreviated to DIACC, DIACC. And they run a comprehensive, in consultation with the law societies, they have developed a comprehensive set of criteria that providers of such authentication services have to meet to be it's an accreditation system, I guess, by DIACC. And that has resulted in a list of providers on the DIACC website, which meet the requirements of the law societies for authentication purposes.
And thank you for pointing that out because I did put a note on my postmortem notes to make sure that next year we do make that proposal to change that.
That
Yes.
I've told you about it because it's an important development,
Yes.
but it's not currently available in Nunavut. Nalini is suggesting that it will likely become so down the road.
Definitely, because members do service communities and the remoteness, it's important to have to make that change, right? Okay.
So there are rules about the timing of verification, and for individuals, it is that the obligation to verify is triggered upon engaging in or giving instructions regarding receiving, paying, or transferring funds. So that needs to be done contemporaneously. Okay, on to verifying the identity of an organization. Given its nature, this is a bit different. So when you're dealing with an organization that is, such as a corporation, that's created or registered pursuant to legislation, it's a fairly straightforward matter. You need to get written information from a government registry that confirms the existence and the address of the organization and the names of its directors where that's applicable. These things can be certificate of corporate status that's issued by that body, a copy of an annual filing, or that kind of document. They vary. The reason for the slightly general language is that these things do vary a bit from province to province, territory to territory. When you're dealing with an organization such as a trust or a partnership, which isn't registered through, it's not created through legislation or registered provincially or federally, then you need to look at a copy of the documents that create the partnership or the trust, such as the trust or partnership agreement, articles of association, and that sort of thing to get the information. There is an additional requirement that applies to organizations, and this is the obligation to identify the directors, shareholders, and what we call beneficial owners. Beneficial owners are those who own or control 25% or more of an organization or of the shares of an organization. So the additional information that's required is set out at Rule 80.62. It includes the names of all of the directors of the organization. You'll see there's an exception for securities dealers. That reflects something that's in the federal regulations. I have to say that in the Law Society world, we shake our head a little bit about that. But in the uh, having taken the approach of modeling the rules on the federal rules, for the most part, the exceptions that appear in the federal rules also appear in the Law Society rules. You are required to get the names and addresses of all trustees or known beneficiaries or settlers of a trust, and information that establishes the ownership, control, and structure of the organization. Now, this information is not always is it's not always easily available. Presumably it's available generally from your client, but in terms of any of your obligations and the rules to satisfy yourself to the authenticity of the information, that's a little more challenging. And as a result, the model rule, but not yet the Nunavut rule, doesn't create an absolute requirement to get the information on beneficial owners. It creates a best efforts requirement and an obligation to record those efforts. You may have heard that governments across the country are working together on developing beneficial ownership registries. There is a federal one. However, access is generally limited and not necessarily available to lawyers. And so for the time being, and as long as that remains the case, the law societies have taken the position that they can't create an absolute requirement because the information can be very difficult to obtain. So in terms of the timing of verification for organizations, you get a little bit of a break. You have up to 30 days to get that information after you've engaged in or given instructions in respect of a financial transaction. It's often easiest to get it at the time, but sometimes it takes more time. There are exceptions to the verification rule. Those are set out in or to the verification requirement. Those are set out in Rule 80.5. You'll see that they essentially mirror those in the some of those in the identification rules and also in the cash rules. But there is an additional exception, and it is still in the rules, although there is some controversy around it, and that is an EFT, an electronic funds transfer. The controversy is because it has been interpreted by some as including e-transfers that you or I might send to pay a bill, and that those are not covered. EFTs themselves are exempt because there's more extensive verification at each end by the financial institutions involved. Okay, so the Law Society has created currently two tools to assist in fulfilling these obligations. The first is an overview, and really it's a one-page chart that summarizes the entire rules for identification and verification. It's a good quick reference. And the second one is a client identification and verification flow chart, which allows you to sort of look at an answer in your mind, the questions as they come up, and decide what next steps you are required to take and what next steps you're not required to take. As Nalini said, those are available on the Law Society's website. These links will be are live in the version of this presentation that's posted on the Law Society's website. And all of that, I believe, is at least these documents themselves are on the same or accessible through the same page as the Legal Profession Act and the rules and so forth.
Yes, we have a slide at the end. If you haven't found the PowerPoint presentation, if you click on the links, then you'll be able to see them. I'm good at Zoom, but I'm still not great. I'm concerned about missing the flow of today's presentation. So we're going to move on to the next slide.
You'll recall that I said that when you're involved in a financial transaction, there are two additional things you must do beyond identifying your client. One is the verification process, and the other is to obtain information and record it about the source of funds. So, what's involved there is, again, pretty straightforward in terms of the obligation that's set out on the first paragraph of this slide. That's Rule 80.61A, requires you to get information and to record it with the applicable date. But what is source of funds? What are we talking about here? So this is a reference to the economic activity or action that generates the funds. So, for example, it's not an answer to say it's in my bank. Money's in my bank. The supplemental question for a lawyer would be, where's that money come from? Is that savings, from your employment? Is it the proceeds of a sale of business or a car or a piece of property? That kind of thing. So you'll see that there's a little bit of detail in on the slide, but the Law Society has also created another document here, which is a document which provides some additional guidance on source of funds.
Asking questions is key.
Yeah, I mean,
Yeah.
basically, you may have a client who you comes in and they have X job and they want to purchase something, and you ask where the money's from. They say savings, and that answer is entirely consistent with what you know about the client. But similarly, you may have a client. Let's take a student with no employment who comes in with $100,000 down payment on a house, and says, yes, they've saved the money, but they have no evidence of employment history that they've given you. That's going to necessitate asking some additional questions about source of funds. One of the very, very many ways in which money is laundered is for the person who wishes to launder the funds to find a proxy to conduct a transaction, and that person is paid a fee for doing so.
And that
And
proxy could be in a current vulnerable,
yeah,
Yeah.
it
Yeah.
could be somebody who's vulnerable. It could be somebody who themselves is dishonest. It could be somebody who
Mm.
doesn't understand what's going on, doesn't realize that they might be facilitating money laundering. But it does happen, and so that's why we suggest that when the information that you get from a client about the source of funds is just not consistent with what you know about that client, you need to ask some additional questions. And let's just take this moment to say that all of these rules are really about due diligence, but due diligence in aid of what? Due diligence in aid of ensuring that you fulfill your obligation under the rules of professional conduct to not facilitate or advise a client how to commit a criminal offense, how to commit fraud, how to commit an illegal act. You have a positive duty in your rules of professional conduct in that regard. And if proceeding on a file would put you in the position where you know or ought to know that you'll be facilitating a criminal offense, you have a positive obligation to withdraw from the file. So all of these rules and these questions that you might be asking clients will help you to assess whether or not there's a risk of facilitating a criminal offense and to turn your mind to what your duties are in that context. Sometimes it's just asking more questions and you get a completely plausible and acceptable answer from your client. Other times, you don't. So Rule 80.9 also requires lawyers to engage in what we call ongoing monitoring. So it's essentially a periodic assessment to determine whether or not what you know about the client and the client's activities, what they've told you about the source of funds and their transactions are consistent with the purpose of the retainer and the information that you have, and also to assess whether there's a risk that you may be assisting or encouraging um, dishonesty or a crime. There are no hard rules about how often you have to monitor the relationship, and in some cases, you're never going to do it because you are dealing with a client with a fairly quick one-off transaction or matter, and you don't have occasion to do more for them, or the matter doesn't extend over a period of time, in which case you don't need to. If a matter extends over a period of time, you need to use your professional judgment in terms of how often you're turning your mind to these questions that are set out in the screen. Excuse me. All right. So just to sort of take you to okay, so we have all these rules. Now what? Uh, I will just turn your minds back to how we got into the business and why the Law Societies got into the business of regulating in these areas. Uh, Law societies have every law society has the same basic mandate, and that is to regulate in the public interest. So it's a pretty straightforward matter for law societies to conclude that regulating to mitigate the risks that lawyers will be knowingly or unwittingly involved in money laundering or terrorist financing is clearly in the public interest. Um, all of both of these activities cause real societal harm, real harm to the economy, and often terrible pain and suffering to individuals in cases, for example, of human trafficking, drug trafficking, crimes of violence, and so on. So ensuring compliance with anti-money laundering rules and acting when the rules are breached is something the law societies take seriously. In all frankness, law societies, when we first introduced these rules, took a pretty low-key approach to enforcement of them. It was a significant change in what lawyers were required to do, and most law societies adopted an educational approach to breaches. So letting lawyers know what they've done wrong and counseling them on how to avoid it in the future. And to some extent, that's still the case because, of course, law societies want lawyers to comply with the rules. It's not all about, slapping them when they don't. But as time has gone on, there is much more scrutiny on law societies, external scrutiny, and on how law societies are doing with enforcement of the rules. So most law societies around the country are taking a more proactive approach to ensuring compliance. So in that regard, of course, the law societies, everyone is the same. They have extensive investigatory powers and the right to require members to answer questions, produce documents. That applies whether the documents are protected by solicitor-client privilege or not. And of course, the law society has extensive powers to audit lawyers' financial records. Many law societies have also added to those audits for compliance with the anti-money laundering rules. Same kind of process, pulling individual files and looking in the files, since there are, in each case, there are obligations to record what you've done in compliance with the rules, looking to see whether or not those rules have been complied with. Law societies can and do discipline lawyers for breaching the rules. As I said, there wasn't a lot of that in the early days, but I would say at least in the last 10 years, there's been a much more concerted effort on the part of law societies to assess whether or not lawyers are complying with the rules and to take action when they're not. The consequences can be severe, and it really depends on what the facts are, of course, as in any other case of discipline. But if there is a finding of conduct unbecoming or professional misconduct, lawyers can receive a reprimand, they can be fined, they can be suspended, they can be disbarred. And the provisions in the Legal Professional Act here in Nunavut provide for the same potential outcomes in the case of discipline.
I wanted to ask you, Frederica, yesterday when we had our in-person event, you were mentioning, I think it's the type of information or the obligation to disclose information. In Canada, that is still very limited compared to other countries.
Oh, well, we have in Canada we have the most robust protection for solicitor client
That's
privilege
right.
in the world. We do have that here. The Supreme Court of Canada has elevated the protection of solicitor client privilege to a principle of fundamental justice with, quasi constitutional principle, and there are many cases in that regard. It's actually quite an interesting evolution over time from a rule of evidence to a constitutional principle. Um, the law societies are, there's an exception for the law societies, not in the law exactly, indeed in some law. Sometimes it's directly in legal professional acts or the law societies rules, but even when it's not there, the courts have held that, to be honest, I find it a slightly strained interpretation, but it has prevailed. And that is that there's an envelope of privilege that the law societies, in order to be able to do their jobs of protecting the public, which is the public interest role that they play, must be able to look at things, documents, information, even if it's protected by solicitor-client privilege. So the end of the envelope of privilege concept holds that privilege is not breached when the Law Society looks at documents that are protected by solicitor-client privilege. And hence the Law Societies can and do obtain that information, and lawyers cannot withhold information when a Law Society comes asking on the basis that it's privileged. There, the Federation of Law Societies, oops, I went the wrong way, has done a couple of reports recently. You'll find them there are links in the documents. One of those reports is posted on their website, is on the effectiveness of law society regulation, and it includes a really comprehensive list of discipline cases and outcomes. And I commend it to you. It's interesting reading. It's interesting to see what lawyers around the country are doing or getting caught doing. On this slide that is now up, you'll see just a few samples. Chosen simply to give you an idea of the range of things that people have done that have gotten them into trouble. But there are many more. As is often the case in discipline cases, there are many cases in which the lawyer has done a number of different things, only some of which are related to the anti-money laundering rules, and that no doubt has affected the penalty. But nonetheless, when you look at the cases, you will see that the breach of the anti-money laundering rules was a factor in the finding of misconduct. So you can see that the first case is a case of just failing to make appropriate inquiries about what the money coming into a trust account was about. There wasn't a sufficient connection to legal services. That's the model rule that I haven't talked to you about, but I'll take this moment to tell you about it because it'll give you a little preview of what's coming down the line, and also tell you that it really applies even in the absence of this rule. The model rule says that money going into a trust account must be directly related to the provision of legal services. So no holding money just because the client asks you to in your professional trust account. If there are no legal services being provided in connection with that. There are discipline cases decided before the law societies in question implemented that rule, which have nonetheless held that a holding money in that regard, in that way, without any connection to legal services, is nonetheless a breach of professional responsibility, because the facts in the cases raised questions about the facilitation of criminal offenses. So even in the absence of that rule, a lawyer here or anywhere else in the country may find themselves in trouble if they allow their trust account to be used essentially for what we call mere banking. And that first case on the slide is a case of what we would call mere banking, no doubt facilitating the criminal, the commission of a criminal offense. But in addition, and the other reason I included this rule is because the lawyer didn't comply with the client identification and verification rules, and there can be penalties there. You'll see that there was an agreement on sentence, and that was a 3-month suspension. In other cases, lawyer's license may be revoked. In the second case, I think it looks like the circumstances are warranted a harsher penalty. But I noticed that the following case, the case from Alberta, there was a 45-day suspension and a $7,500 cost order in a situation where the lawyer failed to identify clients as required by the rules. So it just gives you an idea of the kinds of cases. It is interesting reading, and I encourage you to take a look at the reports. I can tell you that those reports are prepared by the Federation in connection with something called a mutual evaluation by an organization called the Financial Action Task Force. It's a national organization which sets standards for anti-money laundering efforts and terrorist financing around the world. Canada is a member, takes its membership seriously, and this year's mutual evaluation is the first time that the government of Canada sought the input from the Federation and the law societies to paint the picture for the Financial Action Task Force of how lawyers are regulated. And they did so because historically, Canada has been found non-compliant in part with the Financial Action Task Force recommendations, in part because lawyers were not regulated. And we have always taken the position that they are regulated. And this year we were invited to demonstrate how. So you'll find two documents on the Federation's website, which one is paints a picture of the regulation and the regulatory powers of the Law Society, and the second piece looks at the effectiveness of the rules across the country. Um, okay, so now this slide shows you these four new documents, four new tools that the Law Society has created, and I've worked with the Law Society to create. Um, Very open to the possibility of creating others if they would be of interest. There are a lot of interesting tools around the country that law societies have developed, and law societies are generously sharing them with each other. So if you or any of your colleagues, as you work through some of these things, have any thoughts about additional resources that would be useful, or even just questions which might help us to identify additional resources that would be useful, please feel free to let Nalini know, and she and I can talk about how we can assist in that regard. But right here are the links to the documents that we've talked about in the course of today's
I
presentation.
was gonna say, Frederica, so the Law Society has its own duty, like with our regulations and whatnot, but and to make sure that we're on top of things. But we also have responsibly to support our members, right? And providing the tools that they need and help them to be better educated, understanding some of these requirements. So yesterday in our discussion, someone says, "Can you just do like a your due diligence checklist just to support the thought process, especially if you're like more of a junior lawyer of 5 years of practice to help have those red flags um, or asking feeling comfortable in asking questions, right? Especially
Yeah,
in a territory where everybody knows everybody,
yeah,
right?
yeah.
That's important when you have tools. It just helps to make sure that you're on top of things with these obligations.
Uh, Now, I mentioned that the Federation of Law Societies, there are resources on the Federation's website. There are actually really extensive resources. There's a very comprehensive guide to fulfilling your obligations under they refer to the model rules, but it's the provisions that are in effect across the country. There are extensive FAQs and answers. There are specific guidance documents on specific aspects of the rules. And all of those are found on the Federation of Law Societies of Canada's website, where Nalini has shown the highlight in the presentation on the preceding slide. There's a link to that page, to the page on the Federation's anti-money laundering efforts. So you can take a look at that if it's of interest. In addition, on that page, one of the first things is a link to a 5-module online education program on money laundering, anti-money laundering. If you haven't taken it yet, I commend it to you. It's useful even if you're not in private practice. It provides a lot of information on what money laundering is and what it can look like for the legal profession. And also goes through the rules in some depth, providing some samples and examples. The entire thing, entire 5-module program, takes about 3.5 hours. Most people don't do it in one go, but it's not that onerous. So if that is of interest to you, I encourage you to take a look at the Federation's website, and you'll find that online module on the page on their anti-money laundering work.
What I'm thinking to do is on the CLE page for today's event, I'll add those links that we're referring to, even though they're in the PowerPoint. It's good to have them like easily accessible. So I'll do
Mhm.
that in the coming days just to make it easier for our members.
Great. So that brings us to the end of what Nalini and I wanted to present to you today. But if you have any questions, we'd be happy to answer them. Or if you have questions subsequently, send them on to Nalini and she'll forward them to me to answer.
Yeah, thanks so much, Frederica. I'll give it if does anybody have any questions, any clarification, or just general comments? A lot of information to digest,
Yeah, yeah.
and that's okay. All right, I don't see anything in the chat or anything. So thank you again, Frederica. I mean, I'm
Pleasure.
so thankful that have accepted an invitation to share your knowledge and just kind of help the Law Society build some tools to support our members. And I'll do these different updates on our website to make sure the links, the resources are easily accessible. And I look forward to our next session, which we'll be doing remotely. And thanks again. If anything comes up, you know where to find me. There is a designated CLE account. You can also send your questions there. Thanks everyone for joining us. Have
Thank
a good
you.
rest of the day.
Bye.